scope of FORIA's first claim, I will argue that FORIA did indeed undertake a legally binding obligation, that these obligations were lawfully discontinued by FORIA. I will proceed to underline that the act of the building of the Nahash River Dam was done in violation of the Bear Treaty and the United Nations Framework Convention on Climate Change, or UNFCCC for short. My co-agent will proceed by showing that Minister Ordnal was protected by immunities that are provided under international customary law, and that Costats' actions concerning the revocation of the contract awarded to Eftkhar directly violate Bear Treaty's provision on expropriation. In the
so
international
in
law.
all decisions, the result of the maybe consultation done in the International Law Commission are all some sort of soft law, or we have another type of these as well?
Not all of them are, but the most prominent and the most relevant for this case, and the applicant is going to be using the acts of soft law that are passed by the International Law Commission.
Okay, you may proceed.
Agent, I would like to interject you here and ask you, are decisions of this court binding, previous decisions of this court binding on it before us?
Before our present case, decisions of the court, the previous decisions of the court are not binding.
And where has it been mentioned that they are not binding? Where exactly? Can you point out?
Yes, it's Article 38 of the Statute of International Court of Justice.
Article 38 of the statute says that previous cases are not binding?
It says it points out to the list of sources of international law, and it says that court may the court may resolve the issues not binding to that list.
Okay, thank you. You may proceed.
Sorry to interrupt you. Another question is whether, for example, imagine that the state of respondent is going to argue that I was protecting the essential interest and I was protecting the people there because, for example, they needed to, I don't know, take the advantage of electricity or something like that. So what could this kind of so-called protection of essential security interests, or protecting the well-being of the people, be regarded as an exception to observing the provisions of the UNFCCC?
Yes, Your Honor. All of the commitments taken on by FORIA imply an imperative to development of the country, and they are an essential interest of any state to of even a not so developed countries, which Costa being one. But we would like to state that imperative to development does not uplift its obligation of a precaution, and in this case, reasonable EIA application. As I would like to explain, the Costa effectively conducted not sufficient environmental impact assessment, and it had the serious issues regarding the report.
Who is the competent authority to recognize that its assessment was or was not sufficient?
The court may be a competent authority, but as I would like to explain further, the impact assessment that was conducted by Costa directly violates its environmental commitments, especially in regard to the United Nations Framework Convention on Climate Change. So I would like to close my argument by saying that applicant claims that Costa violated its international commitments and responsibilities concerning its handling of the vulnerable and precious Harmattan shrubland area. I would like to thank you for your attention, and I will turn over to my co-agent who will cover the remaining claims. Thank you very much, judges, for your attention.
Thank you. I give the floor to your second agent. Please continue.
Should we wait for him to be able to join?
I think so. Yeah, we give him time.
Can you hear me now? Yes.
Yeah, now we can hear you.
Finally, I'm sorry for this. There's a problem with the laptop. I'm sorry.
No problem. That's technical issues that can happen. So please proceed with your arguments. We will listen now.
Yes, thank you. Thank you, Madam President. Yes, we assume that the charges brought against Mr. O'Donnell are not valid, for assert that the cost is breached under the customary international law by instituting criminal proceedings against Mr. O'Donnell.
Excuse me, Agent, I've got a question.
Yes.
In respect of proving whether the immunity of the Minister of Economy was violated or not, do you have to provide for the court the customary basis for the existence of such an obligation to respect the immunity of Minister for Economy in the case at hand?
In the international environment, there are many doctrines that can describe the immunities, and many
are these doctrines part of customary international law? Because you referred us to Article 25 of the Bear Treaty, which provided that you can read the last sentence of that article, which refers us to immunities under customary international law. So you have to prove for the court that respecting the immunity, or for the Minister of Economy to be enjoyed the immunity from criminal jurisdiction of a foreign state, you have to provide for the court the customary basis. And I didn't hear that in your submission.
And yes, if there are no further questions, I would like to close our pleading. And thank you all for your attention kindly.
Thank you very much. So we turn over now the floor to hear the respondents' arguments. I give the floor to the first agent of the respondents. Please begin with your arguments.
Thank you, Your Honor. May it please the Honorable Court, my name is Evangelos Ioannis Arapis, agent for the respondent. Allow me to introduce my co-agent, Ms. Yanisia Vanikioti. I would like to reserve 19 minutes of our time for my part of the argument, 18 minutes for the argument of my co-agent, and 3 minutes for our rebuttal. In my part of the argument, I will demonstrate that FORIA undertook a binding legal obligation to supply 30% of the funding for each project of the Rebuilding COSTAT program, and that this obligation indeed remains in force. Furthermore, I will demonstrate to this court how COSTAT's actions related to the building of the Nahash River Dam violate neither the Business Environment and Amicable Relations Treaty nor the United Nations Framework Convention on Climate Change. My co-agent will demonstrate that the criminal proceedings initiated by castration courts against Foreign Minister Cameron O'Donnell do not violate immunities under international law, and that by rescinding the contract awarded to the Foreign Resources Administration Corporation, COSTAT has not violated the Bear Treaty's provision on expropriation. Before we argue that the revocation of the Foreign Declaration based on this court's judgment.
Has this court or its predecessor ever found that a state is bound by its unilateral declaration under international law?
Yes, Your Honor. This court in the nuclear test case has found that a unilateral declaration may be binding upon a state. And in that dispute, it found that the French government had indeed undertaken a binding obligation through a declaration as it was publicly delivered and by a competent government authority head of state. Thus, this principle creates a relative obligation of precaution, and it is submitted that the principle should not lead to the overregulation and limitation of human activity.
Excuse me, is this principle part of customary international law, the principle of precaution in this context?
Your Honor, it is argued that it is customary law, but it has not been accepted completely. There can be made an argument that it is developing into customary international law. However, it has not yet reached this status. However, in the present case, it is included in the Bear Treaty. Thank you. This concludes my part of the argument. And should the court have no further questions, I would like to thank you for your attention and ask for your permission to be relieved, leaving the floor to my agent, my co-agent.
Thank you. So the floor is now to your co-agent. Please proceed with the argument for the respondent.
Thank you, Your Honor. Is the audio okay now? Okay. May it please the Honourable Court, my name is Masoudian, agent for the respondent, and I have the honour to argue on behalf of Costa. In my part of the argument, I shall firstly demonstrate that the criminal proceedings initiated against Minister Cameron O'Donnell do not violate his immunities under international law. Secondly, I shall demonstrate that by rescinding the contract awarded to Fraport, Costa has not violated the Bear Treaty's provision on expropriation. With your permission, I will start with the first part of my argument, in which I shall demonstrate that Minister O'Donnell is not entitled to immunity ratione personae, while at the same time he is not covered by immunity ratione materia in the present case of the state official.
Excuse me, agent, would you please clarify for the court which persons or official authorities are to be enjoyed by immunity ratione materia?
Your Honor, all state officials are entitled to functional immunity as long as the state considers them state officials or state organs. This is determined usually in the domestic law of each state. In the present case, we are dealing with a minister, so it is obvious that he is a state organ and could thus, in principle,
what is
be
your main source indicating that the Minister of Economy is to be entitled to this such kind of immunity under international law?
Your Honor, it was adjudged in the arrest warrant case that all state organs are entitled to immunity.
But as far as I know, the arrest warrant case of 11th April 2000, what concerned, it was between the Democratic Republic of Congo and Belgium. So the immunity of Minister for Foreign Affairs was at issue in that case. So why the court referred to this point that all state officials are to be entitled to immunity ratione materia?
Your Honor, exactly because functional immunity derives from state immunity, it protects any state official that is committing an act of the state, because the state cannot act on its own, it can only act through its officials. For this reason, even a Minister of Economy can be, in principle, entitled to immunity ratione materia. My argument.
Excuse me, I have a general question, agent. My question with respect to different type of immunities, immunity ratione personae and immunity ratione materia. So the term and the period that it extends to apply, what is the difference between these two? For example, after finishing their job, their official, and finishing their capacities, for example, after 4 years, imagine that Minister O'Donnell is no longer the Minister for Economy. Is there any possibility to, for example, bring him to the court for an official act conducted during his term of office after the termination of his office term?
Thank you, Your Honor, for the question. This is exactly the difference between personal and functional immunity. Personal immunity is an absolute immunity for all acts the official commits, however, only while the official is in office. Functional immunity only protects the official for official acts, and it protects these official acts even after they have left office. Okay. So in the case that you mentioned, if after 4 years Minister O'Donnell is no longer a minister, he would still be covered by immunity ratione materia for the official acts committed while he was in office.
Great answer. You may proceed.
Thank you, Your Honor. Along with the above, the government of Costa respectfully requests the court to adjudge and declare, firstly, that FOIA undertook a binding legal obligation to supply 30% of the funding for each RCP project, and that this obligation remains in force. Secondly, that COSET's actions related to the building of the Nahis River Dam do not violate the Bayer Treaty and the United Nations Framework Convention on Climate Change. Thirdly, that the criminal proceedings initiated against Minister Cameron O'Donnell do not violate immunities to which he is entitled under international law. And lastly, that by rescinding the contract awarded to Fracorp, COSET has not violated the Bayer Treaty's provision on expropriation. Should the court have no further questions, I would like to thank you for your attention and ask for your permission to be relieved.